Ladies and gentlemen, we're going to attempt to get started. If everybody could please come in, find a seat. I hope you all are in the right room. This is on the very controversial subject of dressing for success. Thank you for coming today. My name is Jay Cohen, and I am the administrator tasked with that responsibility for the past 2.5 years for Vision 2016. I'd like to introduce our president-elect, who is here today to consider and hear all of the information, all of the opinions and shared information that you're here to provide us with as we endeavor to evaluate these issues that have been presented. Bill Schifino from Tampa.
Thank you, Jay. Just very briefly, I do want to thank you, and you and all of the other members of the bar who aren't here today, who have reached out to us and have been very engaged and passionate about this issue. I want to assure you, your Board of Governors, myself and all of the Board of Governors who are here with me today, and the rest of the 52 have listened very, very carefully to what you've had to say on this subject. Jay, I want to thank you for all your efforts as the administrator for Vision 2016. Vision 2016 is not a commission which is solely about this one issue, but it's certainly an issue that has garnered quite a bit of interest. As I come into my office next year, we've got significant issues we're going to be dealing with concerning the Constitutional Revision Commission. I will be reaching back out to you all for your help in those issues. I've spent 2 hours today dealing with P.K. Jameson, our state court administrator, on many of the budgetary issues we're going to be addressing and challenges. But with that said, thank you very much. And Jay, I'm going to turn this back over to you.
Okay. Thank you, Bill. As you can tell, even-handed, he called this issue and your feelings about it just passionate. This forum is being held today with the goal of taking public comment and receiving member feedback on the issue of admission by motion and reciprocity and other Vision 2016 issues. You should have filled out a card when you first came in. Looks like this, if you intend to want to speak on these subjects. If you have not, you can please get a card from the table right outside of the room. If you have a card and you haven't turned it in, please turn it in to Francine Walker right up here on my right, and she will make sure it gets to my table where I can call on you. The speakers will be taken in the order you signed in. You will be given no more than 5 minutes to make your comments. You will not be allowed to waive your time and give it to somebody else, because that would be unfair for us to get through all of the speakers and to hear a variety of their opinions. We will be taking a break only if necessary from 3 o'clock to 3:30, and this forum is being audio taped. And the reason that's being done so is not just for me and other members of the Board of Governors who care very, very much about this issue and your opinions and your senses and your feelings, but it's also so that we can deliver your opinions and the comments that you are providing us today to the rest of our Board of Governors. The Vision 2016 Commission, which I was tasked to oversee, was appointed by then Bar President and my good friend Gene Pettis to perform an in-depth review of 4 general areas that will impact the future of law in Florida: legal education, technology, the delivery of legal services, meaning access to legal services for all, and bar admissions. The Commission's charge was to look at the current impact as well as the long-term challenges that the legal profession will face. And we did this with an intent to accomplish this study within a 3-year period. And that's why it was called Vision 2016, beginning in 2013. The comprehensive study was to provide the foundation to prepare today's lawyer for tomorrow's practice. It was intended to investigate, study, and inform, and if and only if appropriate, to make a recommendation for consideration. The Bar Admissions Subgroup, a hardworking group of individuals, volunteers, began its study 2 years ago and formed 5 committees, one being the Multi-Jurisdictional Practice State Focus Committee, which, by the way, folks, not something new. In 2002 and 2003, the Multi-Jurisdictional Practice Commissions were formed and evaluated some of the very same issues that were presented here again during this study. That committee studied various topics, one of which was admission by motion. A preliminary report was presented to the Board of Governors in July. The board heard the report as an informal report and did not take any action on that report. No action has been taken on that report as we sit in this room today. The issue of admission by motion and reciprocity will be presented at the board's meeting on October 16th, at which time it is expected that a vote will be taken. And that's why you're being here today and giving us your comments and your opinions and whatever other anecdotal information you can provide us is important and is critical and will be considered. Just as the numerous letters, emails, and other modes of communication that have already circulated to the Florida Bar and many, many members of the Board of Governors. I do not know what the final report will say after all of your comments, and I do not know what will happen on October 16th. But what I do know is everything that has been published and everything that you will provide us today will be in consideration. The written comments and the comments from today's forum will be taken into account by not just the committee as they continue their investigation and study of these issues. Let me repeat that. As they continue their investigation and study of these issues before any final report is ever even issued for consideration, but so will your Board of Governors. I'd now like to open up our forum to the first speaker. And according to the cards, the first speaker is Paul Cherry from Sarasota.
Thank you very much, and good afternoon, ladies and gentlemen. I am Paul Cherry from Sarasota, and very frankly, I think that in reading what I have read in the Florida Bar News and in other things, I think we're missing the bigger part of the picture. The biggest part of the picture is the mega firms that exist in Chicago, Boston, New York, Philadelphia, Washington, and so forth, in the large cities. If we allow admission by reciprocity, by motion, these mega firms will inundate us with thousands upon thousands of their lawyers. The firms will pay all the fees. The firms will use the fact that these people are now Florida lawyers, and they can work in Florida just as much as any other lawyer who is admitted in Florida, of course, because they would be Florida lawyers. Florida is still a rural state. The vast majority of lawyers are either in solo practice or in 2 or 3 man firms, if you even want to call it a firm. But that's how we operate now. When these mega firms come down here, they will absolutely and positively snowball us and steamroller us. We've had a few experiences, some in the mortgage foreclosure issue of firms growing too big for their britches and other firms being very large, taking some business from us. We're not so concerned about the lawyers, or we should not be concerned about the lawyers who will be moving here from other states and getting admitted by motion. I have not seen any statistics about how many lawyers actually come in each year by motion now and take the whole bar exam. But we should be concerned about the lawyers who will not be moving here, the ones who will be admitted on motion and staying in their home states of Illinois and New York and Pennsylvania and D.C. and so forth. These are the people we should really be concerned about. And the reason has to do with the fact that they will be, in essence, vying against these 1, 2, and 3-man or 3-lawyer law firms for whatever business we have. We should not be looking so much at lawyer mobility. I'm not so sure how many Florida lawyers want to move back to where they came from, or wherever it might have been. We forget the 3 magic words, and those 3 magic words are pro hoc visa. I had been admitted pro hoc visa in a few cases, the last one, believe it or not, in Tuscaloosa, Alabama. And you can get there if you want to. If your client wants you, you can still have your client, and your client can have you. So there's no real problem in terms of lawyer mobility. I think we're missing the boat here. I think we're going to open up the door to these mega firms coming in here and absolutely and positively destroying the Florida practice. Thank you. I assume my time is up. Thank you very much.
Thank you very much. And I got to tell you, your timeliness is impeccable. You were up exactly at 5 minutes. Thank you. See, we're starting off very good. And I apologize if I mispronounce any names. Some of it has to do with handwriting. Charlie Tiffiant, or Tiffiani?
Tiffany.
Tiffany.
My God, man, didn't you ever get your wife a Christmas?
I'm trying to keep this on that level.
I can just smell it all over this place. Freedom. What a wonderful day. The bar has a chance to enlarge freedom. How often does that happen in any of our lifetimes? Most of the time, we're just making chains to put around ourselves. What did Rousseau said? Man is born free, but is everywhere found in chains. And now, if you side with the people that want to have reciprocity, there may be a few less hanks in that chain. Now, economically, any economist, I've never been able to say that well, any economist worth his copy of The Wealth of Nations knows that the freer trade there is, the more trade there is. The freer we make it for people to come down here and make it for us to go up there, in the end run, we'll have more money. Not much, but some more. I call them the monopolists. The monopolists run around like people from the late Dark Ages. They sit around after church and they say, A furore, Normanorum, Liberia, Nos Domine. From the fury of the Northmen, Lord God deliver us. Who are these Northmen that are coming down here to eat up our sustenance? You know, what's incredible, most of them are just like us. They're afraid to live and they're scared to die, and they got one more shot, and they're going to get on I-95 and head south and realize by the time they get to Delaware, it probably is not going to work out, because when they get there, they meet themselves. So we shouldn't be worried about these people. They're people like me. If you need a monopoly to protect yourself from people like me, you ought to work the fry counter at Mickey D's. Freedom. I wrote a Florida bar opinion, and I accused the monopolists of being motivated by greed, avarice and mendacity. And I was wrong. And worse than that, I was a sounding brass. I was without charity. It's not these people coming down from north that's scaring everybody. It's this fear that is just running over the profession that something is wrong, and we can't put our finger on it because we're afraid to look down in that abyss of fear and see what's looking back at us. And it's simply this: we have to accept the fact the law business is not as lucrative as it used to be, and you're not guaranteed a trip in the upper middle class when you get a ticket from a good law school. Since 2007, there's been an absolute decrease in the number of car crashes throughout the country by 25%, and the same number of less crimes. It doesn't take that guy Watson, the computer, to figure out what effect that'll have on us, but that's nothing compared to the real problems. 58% of the children in Florida today are on free or reduced lunch, which means they're living at or below the poverty line. That's 60% of our possible client base. This country is being hit with a tidal wave of penury, and no monopoly is going to protect us from this wave that's coming across the nation like a 1935 sandstorm. So what do? Well, why not try a little freedom? I've never chewed anything or tasted anything or bit anything that was made worse if you dumped on some hot sauce of freedom. Freedom, the most incredible thing in the world, taken for granted by those that have and only dreamed about by those that don't have it. I envy everybody here today. I envy you all, because a month from today is going to be the 18th of October. And that day, years from now, a generation from now, you're going to be home, and you're going to see the 18th of October. And you're going to rouse yourself, and you're going to say, it's the 18th of October. And then the door's going to fly open, and your grandchildren are going to come in, and you're going to reach down and grab them, and one of your grandchildren is going to say, Granddaddy, Grandma, why are you celebrating the 18th of October? And you're going to say, that's the day I looked fear right in the eye and stared it down, and I struck a blow for freedom, not only for my fellow Americans, but especially for you. Thank you.
Thank you, Mr. Jared. Tiffany. I'm sorry. The next speaker, for those of you who have come in a little late, if you want to speak, please fill out a card. There were cards outside. If you need a card, Francine Walker right up here at the front has cards for you, and we'll get them up front so you can, I'm sorry, cards are in the back. If you fill them out, I promise you, you'll be heard. Next speaker is from Tampa, John Hamilton.
I'm kind of afraid to get up here after that speech. Because I'm about to be opposed to freedom, for God's sake.
And you're John Hamilton.
And I'm John Hamilton. Since we've got only 5 minutes, I'm going to curtail some of my comments, which I made in the previous town hall meeting that we had. And I want to go over a few things with regards to this proposal for reciprocity. And I'm going to not deal with the fact that the survey is not representative of Florida lawyers' opinions. The survey was flawed. The question was, in fact, biased and had a acquiescence bias to it. Wasn't done correctly. But be that as it may, let's talk about what the report said. I'd had an opportunity to read the report. I wish I had more opportunity to read it closer. But one of the things that interests me in the report is the statement by the subcommittee where they said, if the Florida Bar's mandate is to protect the business interest of its members, then admission by motion would be contrary to this mandate and should not be adopted in Florida. It's an absolute admission by the subcommittee that this is not in the business interest of Florida lawyers. But the way they try to justify it is to contrast it against what our mandate is which is, of course, to try and serve the people of this state. And they're trying to indicate that it's a question of, are we being protectionist to the lawyers to the contrary interests of the citizens of this state? I don't believe it's so, and I don't believe that they've made their case. Let me give you an example. The underlying assumption of the entire report by the committee was that it was in the best interest of Florida citizens to increase the number of Florida lawyers, presumably because we have some sort of shortage of lawyers in this state and therefore don't have access to lawyers, and that because we need to do so even if we have not determined that these lawyers can pass a minimum competency test with regards to our statutes and our Florida law. And that's what we should do to solve the problem. Well, in my opinion, I disagree with that. First, let's deal with the shortage of lawyers issue that is implied within the report. First, according to the American Bar Association National Lawyer Population Survey, from 2005 to 2015, the average increase in lawyers per state was 17%. In Florida, we were 53.3%. I wonder why that is. Ask yourself that question. According to the same survey, the average increase for 2015 in that year alone for states was 1.5%. Florida, again, was higher than any other state in the nation at 8.5%. We have more lawyers in this state than any other state except California, New York, and Texas. We're in the top 20 states of per capita lawyers per our residents. So clearly the facts show there is no problem with access to lawyers in this state by our residents. That's not a justification for this proposed policy of having reciprocity. And reported in the New York Times, according to the Economic Modeling Specialist, Inc., which is a consulting company that focuses on employment and economic analysis, they looked at data from the Department of Education on law school graduates each year to get a measure of the quantity of new lawyers, estimates for the number of openings based on the data from the Bureau of Labor Statistics and the Census Bureau, something, by the way, that was not done by the subcommittee. According to their study, every state but Washington and Nebraska is producing more lawyers than it needs. So we don't need more lawyers down here to serve the interests of our people. Approximately 49% of our law school graduates cannot find long-term jobs. No impact study about this, about the impact on lawyers in Florida, on the impact of the residents of Florida was done when this subcommittee did their report. And I commend them for trying to do it. I commend them for the work that they put in and the time they put in. I just disagree with their conclusions. I ask you to search the internet, if you will, and ask it to find you a publication that complains there's a shortage of lawyers in Florida. Try it. Nothing will come up. You might include, we might change that to surplus, and you'll find a lot of articles, okay? I challenge the bar and the subcommittee to prove by data that there is a need for more lawyers in Florida to serve the interests of our citizens. I challenge the subcommittee and the bar to prove that more lawyers in Florida helps us compete with something like that I've heard in the subcommittee, in the last meeting I attended, with the likes of LegalZoom. I don't think there's any relationship between the two whatsoever. I challenge people to prove that reciprocity will help the vast majority of Florida lawyers, from individual practitioners to small firms, which is what Florida is primarily made of, as opposed to the large multi-state firms, as the other gentleman mentioned. So far, the subcommittee offered to me no concrete facts to explain why, to Florida lawyers, why reciprocity is either good for our citizens or good for the Florida lawyers that the Florida bar is serving. One last comment, and I do this because I've really started to get into this, and I don't want to suggest that there's an ulterior motive that's happening here with regards to this reciprocity issue. But we hired, apparently, a media firm to engage in media work, okay, for this issue. It's the Schwartz Media Strategies. Who recommended him? What have they done on this reciprocity issue? I would like to see all the communications that they have with everybody they have contacted, and I want to see what they're promoting on behalf of the Florida Bar. That's $96,000. That's $96,000 of our money that is being used by a media firm, and we have absolutely no access to the data of what they're doing. I think that's atrocious. And I'm done. Thank you.
Thank you, Mr. Hamilton. Jason Mulholland from Tampa.
Good afternoon. Thank you. Thank you for the opportunity to express just a couple of concerns. I won't take my whole 5 minutes. My name is Jason Mulholland. I'm a solo practitioner here in Tampa, Florida. I've been operating my own law firm for about 13 years now. I have two little concerns about and one of them is directed at the non-lawyer ownership of law firms. My concern about that is that a non-lawyer is going to have an inherent conflict of interest between the loyalty that it would owe to its shareholders versus the duty of loyalty that we as attorneys hold to our clients. And so I think that needs to be, in particular, an issue that is explored in detail before they consider adopting any non-lawyer non-lawyer ownership of law firms. Secondly, and reciprocity ties into my second concern, is that there's a concern that inviting in additional lawyers, inviting in private equity investors, non-lawyer ownership of law firms, my concern is that these law firms are going to grow to the point where they're too big to fail. They're too big to jail. They're going to be too big for an already under-resourced Florida bar to effectively police and regulate the number of activities that they will then be able to engage in, not the least of which is the unauthorized practice of law. So I just wanted to share those two concerns. I appreciate the committee making themselves available to listen to comments from the membership.
Thank you, Mr. Mulholland. The next speaker is Ted Starr from Pinellas Park.
I, too, am a sole practitioner, work in Pinellas Park. I had one point I wanted to bring up to the board, and it had to do with the proposal that we saw written. And I think clients, people of Florida, are being forgotten in this proposal. A lot of talk about lawyer competition and competition among our peers, but the clients are being forgotten because we're going to have these out-of-state lawyers descend upon and sue our clients. I point the board in the direction of Channel 7 in San Diego that on June 24th of this year discussed an audit of the California bar. They got 250,000 lawyers in California, and they haven't adequately disciplined or policed their own lawyers, and they admit it. They said that their cases are backlogged. They can't get to and prosecute all of their cases in California, and so this board proposal says, well, someone with a clean record can come to Florida. Well, these lawyers are going to come here with a clean record because the Florida bar, which one of its mandates is to protect the people of Florida from practitioners that are inadequate in Florida, is going to have to rely upon what is clearly inadequate bars in other states. And so I don't think our bar should and can do that. So therefore, we're going to have California lawyers coming here that don't have a disciplinary review that our people are going to be expecting. And so I think it's inappropriate to allow these lawyers to come in here when they're not adequately reviewed. So I think we're not protecting the public, and we're letting the people down, my clients down, because my clients are going to have to defend themselves against these out-of-state lawyers. So that's the one point I want to make. In this California audit, June 24th of this year, California admits that they can't police their 250,000 lawyers. So we're going to have those people coming in and those inadequate lawyers coming to Florida. So I think the bar is setting itself up for admitting lawyers into this state that haven't been adequately policed. So this proposal is totally forgetting the people of Florida. That's my point. Thank you.
Thank you, Mr. Starr. Next speaker is Lawrence Steele from Ocala.
Anybody that listened to Richard Susskind in South Florida a couple of months ago, if they didn't listen, they need to read his book. It's not just about protectionism. It's about the whole practice is changing. The very reason the bar, which traditionally doesn't take this type of input from its membership, but is now, is because it's justifying its 30 years of tyranny against sole practitioners. The bar is heavily biased in every respect against sole practitioners, particularly the disciplinary system. If you're a sole practitioner, I work with 2 or 3 other lawyers. Anytime the bar or some member of the public is dissatisfied with a case, they write a letter to the Florida bar. The bar puts in its exercise of jurisdiction and protecting the public and all that stuff. Where the large law firms, it doesn't apply because the type of work that large law firms do is not the type of work that people like me do, or the other guy from Sarasota. We are the backbone of the practice of law in Florida and in the country. The lawyers that deal with the bankruptcies, that deal with the divorce work, that deal with people being thrown out of their houses, we do that. I don't know what your practice is, Mr. Cohen, but unfortunately, my experience has been that the bar does not represent us. Not really. This is an interesting forum, but this should be a two-way discussion. As you said earlier, this is taken in conjunction with three other areas that you're dealing with. I think if you listen to Susskind and other speakers, it's the correct thing. Protectionism doesn't work. Protectionism doesn't work I'm from England, obviously. Protection doesn't work in Europe. It doesn't stop migrants leaving Syria. You can't keep them out. So I think Mr. Tiffany or somebody had written a letter to the Bar News said we should build a wall all the way from Tallahassee all the way over to Pensacola. It might keep a few lawyers out, but in essence it won't. But I think the real point here is, I think, yes, it's a great idea, but we do not need 52 or how many Board of Governors to decide. Every lawyer in the state has an email. It should be an important a decision of this magnitude. Every member of the bar, just like anything else, we've all got emails, should be sent a form when at the right time and decide. We have 100,000 people, I don't know how many are practicing, and the majority wins. If the majority of the bar says yes, fine. If the majority of the bar says no, forget it. That's it.
Thank you, Mr. Steele. And I guess just by way of introduction, I should have explained, I've been on the Board of Governors for 6 years. My practice is from Fort Lauderdale. I have a 4-person law firm, and I represent innocent victims of medical negligence. So very much like you. Next speaker. Thank you, Mr. Steele. And I thought it was from South Carolina. I don't know why. Our next speaker is Charles Moorhead from Fort Lauderdale.
Somebody's watch is here. A nice Rolex. I'll take it.
That's mine. I didn't pay attention to it when I spoke, right?
Yeah. See, they're so rich, they're throwing them around. Thank you for allowing me the time to speak. I do wish that Mr. Abedin was here. I'm sorry you're here to take the bullet for him, but I suppose that's the way it is sometimes. These proposals, I'm from Broward County. I'm the president-elect of the Broward County Bar Association. I'm also the president-elect of the American Board of Trial Advocates of Fort Lauderdale. I sit on the board of the Broward Justice Association. All three organizations have come out with proposals, or not proposals, but resolutions against this reciprocity proposal. It is, in our view, ill-conceived and little more than an attempt to allow large firms to flood wherever they wish with lawyers. The people of the state of Florida deserve more. And if I wanted to go to Kansas or New York or California and represent folks there, I would have no problem sitting for, studying, and taking their bar, proving my competence, and moving ahead. And here, a wave-in, thank you. We all did it. And the truth is, I look back, I learned a lot when I studied for the bar. I hate to admit it, but it's true. And, you know, there's a reason we have these bars that we pass, whether it's the college entrance exam, the LSAT, the Florida bar, and then board certification, of which I'm thankfully board certified. I sit on the board certification board for Florida Bar. So when you look at this proposal and we read the 397-page report, what do we really find? We find in section 39, page 39 of the 45-page core report, that the Pro Hoc Vice system is, according to the panel, working well, and they recommend no changes, that there is no shortage or inability of lawyers outside the state or anywhere else to come to Florida and practice law. That's what their own report says. If that's true, I have no idea why we would open up the floodgates and not have proper testing and appropriate motion and allow the Florida Bar to decide who actually becomes a member. I'm unaware of any organization that has considered this issue and rendered a proposal and supports it. None. And if there are any, I'd love to hear who they are. Not the Florida Justice Association, who recently voted to not support this. The American FLABOTA, the Florida American Board of Trial Advocates, they oppose it by resolution. Every organization that I'm aware of says it's a bad idea. The poll running on the Florida Bar website overwhelmingly is against this idea. How that squares with this so-called random poll that was done 2 years ago, I don't know. But what I do know is the people of Florida deserve to be protected, and we should have this voted down, tabled immediately.
Thank you, Charles. Charles is a good friend from Fort Lauderdale, and I want to just make a comment that I appreciate his appearance here like I appreciate every one of your appearances, because I know it's on your own nickel, just like every Board of Governor who travels throughout the state to attend meetings and other things. It's on our own nickel. And what I would like to point out, and as much appreciation as I have for Charles and all of you who have spoken and are here on your own nickel, I'd like you to know just the Board of Governors who are here. Could every Board of Governor of the Florida Bar please stand up and at least be acknowledged that you're here, listening, attentive, and care? Thank you. I'd like to call our next speaker, which is Peter Roman from Clearwater and Hudson. No? Peter Roman?
Scared him off.
Clearwater and Hudson. Okay, if he comes back, I'll be more than happy to call on him. Our next one is Karen Scanlon from Chicago.
Is it safe? Hello. Thank you for the opportunity to speak with you. My name is Karen Scanlon. I am with an organization called Military Spouse JD Network. Essentially, we are a 1,000-member National Bar Association comprised of attorneys married to service members. Our mission is to reduce licensing barriers for military spouse attorneys. I came here today just to really drive home that we are not asking for reciprocity. What we are asking for is a temporary license while we are with our spouses while they are on orders in your jurisdiction. Florida, you have 29 military bases. You have great support for the military community. And frankly, I love your bar. You guys are great. Good show of...
Can you repeat that again?
I said, I love your bar. You guys are great. Over the past several months, we have been discussing the possibility of introducing a rule to the Board of Governors in Florida, working with the Vision Commission 2016, and we thank you for your time. We want to encourage continued discussions, and we would like to ultimately see Florida join the 13 other states and one territory that have passed a similar rule in support of military families. Thank you.
Thank you. Thank you, Ms. Scanlon. Next speaker is Gerald Heckler from out of state.
Actually, it's Gerard.
I'm sorry.
Yeah,
Gerard
right.
Heckler.
Yeah, I did want to say I have a pretty unique perspective on this. I was admitted to the Florida Bar in May of this year. I have an active law practice in New York, where I've been the last 10 years. Prior to that, I was 25 years a lawyer in L.A., and prior to that, 8 years a lawyer in Chicago, and along the way, practiced a couple years in Boston. Of all those jurisdictions, I sat for the full bar exam in Illinois and in California, took an attorney bar in Massachusetts, and was admitted on motion in New York, my home state. I came down here, took the Florida bar while operating a very active sole practice, studied for it, passed it, and as a result, I actually believe I'm a better lawyer. I think that it actually surprised me quite a bit to even have this idea come up of admission on a motion down here, because I will say, having done it the way I did it and having to take this test, I really appreciate my license in Florida much more than if I had just been able to do it by motion, come down and hang the shingle on the wall. I don't think that there's anything to be gained, any advantage to be gained for Florida by reciprocity. If I, after practicing law for 45 years and operating a full law, busy sole practice, if I can study for the bar and come down and take the bar exam, there's no reason why other lawyers can't do that. And I think it's a very bad idea. I think it's not going to improve Florida's law practice in any way, shape, or form. And I really question the motivation of the people who are behind that idea.
Thank you, sir. Our next speaker is David Jamunder from Tampa.
Well put. I've taken 3. Thank you. A number of our colleagues have already spoken about the financial implications to their practice, so I'm not going to discuss that. What I would like to mention are just a couple of points I thought of. I originally started practicing in Ohio back in 1999, and I started wanting to practice down here in Florida in 2000 when I took the bar exam. And I was struck while I was in the middle of my barbary course by how specific a lot of the questions were for the multiple choice portion of the exam. And so I asked several of the instructors over the course of the time that we're studying, why is this exam structured this way? And they said that, and they said this uniformly, that it was structured that way because the Supreme Court, and I guess the bar, wanted to effect a barriered entry because they were really concerned about snowbirds coming down to Florida, hanging up a shingle, practicing for a few months, and then heading back. And they were even more concerned with snowbirds of an advanced age who might not be able to practice at full capacity coming down here. That was for out-of-state practitioners who wanted to take the bar exam, not by motion, but those are people who actually wanted to come to the bar. There were already restrictions, just people wanting to take the bar. It's a real concern, I think, for all of the Floridians who need legal services. The second point I wanted to mention is I found this interesting article that the Tampa Bay Times published on September 11th, and they listed what other states do. They got their information from the Florida bar, so I'm hopeful that it's accurate. 15 states, 15 jurisdictions, I should say, already have admission by motion without reciprocity, which means that any of us in this room could go to any of those states, including what's listed here, D.C., Illinois, other states, and get admission without doing anything whatsoever. Another 11 states, including, and there are another 3 states that have a modified version of admission by motion without reciprocity. Another 11 states, including Florida, have no admission by motion whatsoever. And so whatever we do here isn't going to affect that unless those states change. What that means is that there are perhaps as few as 22 states, jurisdictions, that this proposal would affect, so that we'd be able to go practice with them if the Florida Supreme Court approved your proposal. That would include such legal powerhouses, burgeoning legal markets as Arkansas, Idaho, Kansas, Kentucky, Maine, New Hampshire, South Dakota, Utah, West Virginia, Wyoming. I mention this because it was stated in some of the bar materials that the supposed premise for this was to make sure we have the ability to go practice wherever we want. And maybe there are untapped number of Florida lawyers wanting to go practice in those markets. I tend to doubt it. So what does this mean? To put it in specific legal terms, this is a dangerous idea. This is an ineffective idea. This is a foolish idea. It's not going to really achieve, I think, what you're telling everyone that it's going to. And if the Board of Governors really wants to continue to pursue this, I'll echo one of my colleagues who spoke earlier. You need to have a full, open, well-publicized referendum of all of the bar members. And if you don't elect to do that, then I think, frankly, the membership of the Florida Bar should really investigate options for making this a non-unified bar and not making bar membership mandatory, because obviously you're not representing the will of your members, and more importantly, you're not representing the clients that we have all throughout Florida. Thank you.
Thank you, sir. Our next speaker is Josh Chilson from Clearwater.
Good afternoon, Governor Cohen, President-elect Schifino, and the rest of the members of the Board of Directors and other fellow Florida Bar members. My name is Josh Chilson. I'm the immediate past president of the Clearwater Bar Association. I'm here on behalf of our 15-member Board of Directors who on August 4th unanimously passed a resolution opposing the proposal that's currently being discussed. Our board represents approximately 1,000 lawyers and judges in North Pinellas County. We did not survey the entirety of our membership because of cost concerns, because we are a small local voluntary bar association. However, our board did informally discuss the proposal with our membership, including myself. I probably spoke to almost 100 of our members. I've spoken to 2 of our members, 2 out of 100 that actually are in favor of this, and they're in favor of it because they're younger lawyers and they wish to move back to a home state without having to take the bar exam in that particular state. And when pressed further, they were in those states that already have admission by motion without a reciprocity component, so they can currently motion in regardless. Obviously, there's a protectionism component to all this. I think that we should be concerned about the interest of our fellow lawyers. However, many of the speakers that have already spoken have spoken about the fact that this is not in the best interests of the Florida public, which I think should not be lost on the Board of Governors when they consider this. It is not too much to ask for lawyers who wish to practice law in the state of Florida to demonstrate at least some minimum knowledge of Florida law. We obviously are a government of the federal government, and we have principles of federalism. The laws in the state of Kansas and New York and California are different than the laws are in the state of Florida. And I think that throwing out a requirement that people demonstrates at least some minimal knowledge of Florida law before they practice law in the state of Florida, and especially with the snowbirds, is a very serious concern. So on behalf of our Board of Directors, who represents approximately 1,000 members, I'm here to formally present our resolution to Governor Cohen and to the rest of the board. And I appreciate the opportunity to be heard today. I am willing to answer any questions on behalf of our board or our members that anybody may have. So thank you.
Thank you, Josh. Appreciate it. Our next speaker is Lloyd Schwed from Palm Beach Gardens.
Thank you very much, Jay and Bill and the Florida Bar for scheduling this forum. I think one of the reasons so many lawyers have been so upset about this is I think that they felt that this forum should have come before the bar president was going around the state advocating for reciprocity. And it should have come before the subcommittee spent 2 years studying this, but didn't ask the 101,000 members of the Florida Bar who pay $26 million a year to fund the bar. And I think they were also upset because the subcommittee report after 2 years attached 3 letters to it, 3, all in favor of reciprocity, that's not studying an issue. And then when this all kind of came out, because the president was going around saying it's inevitable and we got to do this, and they set up an email address, lo and behold, over 1,100 lawyers wrote in and said how damaging this would be to the Florida bar and to Florida citizens. And there are 3 letters attached to the subcommittee report. What kind of a subcommittee study was that? I mean, that was a position piece. It was the deck was stacked. It wasn't an objective or impartial study, and it upset a lot of lawyers. And you know, this isn't about freedom, Mr. Tiffany. I'm sorry. It's about democracy, is what it's about. Part of freedom is democracy, and democracy requires that the people that your actions are going to affect have a say in it. You don't just have 3 or 4 elite people at the top who decide what's best for everybody. And it's not about freedom, because you have the freedom right now to go to 16 states and practice law tomorrow. And if you want to go to a state where you have to take a bar exam, you have the freedom to spend 60 days, study their law, and take the test and show you're competent. And I doubt very much that if one of your family members was involved in a serious accident, was maybe a paraplegic for life, that you would want to go out and hire a lawyer who doesn't know the first thing about Florida law, hasn't been tested about Florida law. I doubt very much that's the case. I'm not the greatest lawyer in the world, but I find it very powerful that a man who has spent 43 years practicing law here, Florida Supreme Court Justice Fred Lewis, who has spent decades fighting for access to justice, just last week was asked about this, and he said, quote, "I think it's absolutely the worst thing that could happen to the citizens of Florida. You cannot do a car wreck case in Florida if you do not know and understand the Florida statutes. You cannot do a medical negligence case unless you understand the Florida statutes. Everywhere you turn, there are statutory provisions unique to Florida." What is so hard to ask of out-of-state lawyers before they're given the privilege of a Florida law license to take a test and show that they have studied a few things about Florida law? Why is that so much to ask? That's not freedom. That's about competence. The thing that has been wrong about this process, and I know I'm running out of time, but your bylaws say that the bar president is the spokesperson for the Board of Governors and for the bar. He's not the spokesperson for himself. And the Board of Governors under the bylaws have the exclusive authority to fix, formulate, and set policy. And from everything I've heard, the Board of Governors is going to vote against this. So why is the spokesperson for me and the spokesperson for the Board of Governors going around advocating for something that all of us are against, or 88% of us are against? That's the problem. And why are we spending $100,000 in our bar dues on a PR firm that's going around getting editorials placed in every newspaper saying that we're trying to protect ourselves and that this is a bunch of lawyers trying to create monopolies? Well, that's not how our bar dues should be spent. And if you're concerned about access to justice, use the $100,000 for legal aid. And the last thing I want to say is, if Mr. Abedin thinks this is such a great idea, in about 9 months, he can go around the whole state and tell everyone what a great idea it is, and do it on his own time. Don't do it on our dime. And that's all I have to say.
Thank you, Mr. Schwed. Our next speaker is David Carter from Seminole.
Okay, good afternoon. I have practiced law for over 40 years here in Florida in the areas of probate, accident injury, and bankruptcy. I no longer maintain an office. It's been about 2 years, but my license is still active. I'm affiliated with an estate planning firm and a litigation firm over in Pinellas County. I just have a few observations that in my 40 years plus of practicing law, every day I learned something new about Florida law that I didn't know. And in learning that, I was aware of maybe 4, 5, or 6 things regarding Florida law that I should know. And this was pretty much every day. I don't see how an out-of-state attorney who takes a course and gains admission to practice here in Florida is going to really know what is going on in Florida law. Clients and prospective clients usually ask questions on out-of-state law regarding probate, real estate, family law, and accident injury. My response to that was always talk to a lawyer in that state or your home state. Now they can go online. But my liability carrier always advised me, be very careful about doing any documents or giving any advice on the law in another state. And I think that was excellent advice. I took the leeway of looking up Attorney Aberdeen's law firm in South Florida, and it's the Sedgwick LLP law firm. 1 office in Miami, 2 offices in Fort Lauderdale, and 1 in Hollywood. And on its website, and I'm quoting, it boasts that it's an international litigation and business law firm with more than 300 attorneys and offices around the world. Obviously, and it also says that its collective experience spans the globe and virtually every industry. Obviously, our president practices all over the country and maybe the world, while the average Florida lawyer sweats meeting monthly overhead. And I just don't think that the average lawyer goes around writing checks for $96,000 to a PR firm. It's just, I think what I'm saying is that our distinguished bar president just practices law in another world, and he's a fine gentleman and a great lawyer, but most lawyers are not in that universe. So that's all I have to say.
Thank you, Mr. Carter. Our next speaker is Pat LeDuc.
Yes.
LeDuc, thank you, from Tampa.
Again, my name is Patrick LeDuc. I'm just a sole practitioner. I'm quite humbled to be here. I think today's meeting speaks volumes about the professionalism and the quality of the lawyers we have here in Florida. I want to thank both of you for your comments. I came to speak because I wasn't expecting this. I thought I'd walk in and the fix was in, that this was going to happen. I think I'm opposed to this, and I think for all the reasons that were stated, I don't need to reiterate them. I'm a sole practitioner. I've been doing it for 22 years, but I happen to also be a colonel in the U.S. Army Reserves. I'm assigned over here at Central Command. I have the privilege of working. I've been there 2.5 years in our nation's most important combatant command. I view things through a military mindset. I've been doing that for my entire life. And this has to be a humbling experience, I think, if you're the president of the Florida Bar, hearing your membership speak so strongly about this. It really irritated me as an Army lawyer when the decision makers would make decisions without taking into account how it would impact in a negative way the trigger puller. This is why we have lawyers in the military. We're counselors. We're like BASF. I don't make the orders, but I try to help the orders become better. I don't make the rules, but I try to help the rules become better. And that's what we try to do. We try to protect our commanders from making stupid decisions. I think our membership's trying to protect our leadership from making a very stupid decision. I don't need to get into a lot of reasons why. You've heard them all said much better than I could ever articulate them here. This is a bad decision, and I think clearly, I think that message is going to get through. I'm proud of the membership for that. Thank you for the things you said. I would make 2 points. And again, these may not be accurate, but I think they're pretty close. You know, the Gideon, I do criminal defense work mainly. The Gideon decision came from Florida. We have the public defender system. We should be proud of that. But what's happened now is almost 80 to 90% of our felony clients are qualifying for the public defender. Stated another way, it looks like the indigent are the entirety of our crime wave. Most of them can make a bond, and yet they immediately get a public defender assigned to them. I've spoken probably to 100 attorneys who were like me. You know, we practice criminal law. I talked to one attorney, I don't know whether it's true or not, but he indicated to me that he knew the valedictorian of Barry Law School, couldn't get a job. The valedictorian. I don't know if that's true, but I think it is true that a lot of our law students struggle to find work. I think that a lot of our private sole practitioners are struggling day to day. And one of the things we need, and I would hope the bar would consider, is this issue of the public defense system. I was a public defender. I'm in favor of it. But the question becomes of whether or not we're providing welfare to the criminal class in the form of free legal services when it can be afforded. A lot of people can make a $10,000 bond but won't pay for an attorney for $1,000 or $2,000 to represent them because we automatically, willy-nilly just assume they qualify for the public defender. I've talked to a lawyer the other day who said a medical doctor driving a Mercedes-Benz but was having a public defender representing him. And I find that to be interesting. So I would ask the bar to consider that. I know it's easy for the judges. They just assign a public defender and the system moves. But maybe, you know, when we have, when people can bond out on a third-degree felony or a second-degree felony, and I'm not talking about people charged with life felonies who can't make bond. They're clearly indigent. They deserve to have an attorney. But maybe this is something the bar can consider, because if we're talking about opening up the floodgates, then one of the things we should consider is how we as attorneys can represent a group of people who probably could afford to hire us. Last point, and I'll stand down. I want to thank you for what you've done and your service. As an Army Judge Advocate, I was at 3rd Infantry Division, and 3 of my colleagues who are captains, all of their wives were attorneys. I would encourage the Florida Bar to consider what Ms. Scanlon said. It's not going to be a major impact. It may only affect maybe a half a dozen people here in the state of Florida. But there are Air Force, Marines, Navy, and Army Judge Advocates whose spouses are attorneys who are from other states. And there may be something that we should do to help them, and I would ask the bar to consider that. In closing, again, I want to thank the membership for coming out so strongly against this. Thank you.
Thank you, Mr. LeDuc, and thank you for your service. I'd like to call as our next speaker James Vicarius. Vicarius.
Thank you, Mr. Cohn.
My pleasure.
My name is James Vicarius. I'm here for a couple organizations today. So the first is the Seminole County Bar Association. I'm this year's president. And the Central Florida Trial Lawyers Association, I'm an officer of that organization, has also asked me to come over. So the Central Florida Trial Lawyers Association has approximately just under 1,000 members. The Seminole County Bar Association has around about 250 members. The vast majority of both our organizations, so about 1,200 people or so, are against reciprocity and non-lawyer ownership of law firms. I'm not going to go into what everybody else spoke today, but I want to talk a little bit about organizationally what I see here with the Florida Bar. You know, as I drove here today, spent some time yesterday talking to some students at for 1Ls at Stetson College of Law, and it was a lot of fun doing that. I'm a '93 graduate of Stetson, so it was fun to hang out with the dean and listen to some trial prep that they were doing for the trial team. But on the way over here, I passed a funeral home, and there was a long line of cars getting ready to go on to the funeral itself. And for some reason, I thought of the Florida Bar. as I looked at that. And I kind of felt like I was coming to a funeral today. And here's why. We have a very special thing going on with the Florida Bar, and I know a lot of people have complaints about it. I personally have some complaints about it, but the big picture of it is, it's imperfect, but it's a great jurisdictional organization, because as we all know, the Florida Supreme Court, at the end of the day, as a third branch of government here in Florida, is in control of the Florida Bar and is in control of disciplining us as attorneys and to letting us in to practice. If we chose as a bar to admit people, other lawyers from other states, through a motion by reciprocity, we give the legislature a very, very handy tool to remove the jurisdiction of the Florida Supreme Court to regulate and license and discipline lawyers and give it to the executive branch. And as we all know, as lawyers, all our other federal professionals are disciplined and admitted and licensed by the Department of Professional Regulation in Florida. I do not want them regulating me. I would much prefer the Florida Supreme Court regulating us. Now, let's take that one step further. Let's say we take the step as a bar, put our neck into the noose and jump off the gangplank, so to speak. The legislature, a future legislature, decides to revoke this jurisdiction, and the next step is does the Florida Supreme Court and the Florida Bar, does it have jurisdiction to make membership mandatory anymore? I mean, we just heard earlier that the dues being collected is $26 million a year. As somebody who's an officer of two voluntary legal organizations, I can tell you it is extremely hard to get members to voluntarily join a voluntary bar association, and it's extremely hard to collect the dues. So if the Florida Supreme Court thinks and the Florida Bar thinks it's hard now to make their budget, just think about it after this rule goes through and the legislature yanks that. Do I have any other time?
Yeah, you have another minute.
Okay, thank you. Another thing that I see, especially as a president of a voluntary bar association, so of Seminole County, is how much distance has opened up between the Florida Bar and the voluntary bar associations. And the voluntary bar associations is where the rubber meets the road oftentimes. It's where local people call up and say, hey, I need an attorney for whatever. Who would you recommend for this? That's where they're coming to. This is where the local judiciary comes to meet with fellow lawyers in their geographic area and break bread with them and talk to them. What is going on here is driving in my opinion, is driving such a wedge between the many voluntary bar associations in Florida and the Florida Bar. And it worries me because I care about the Florida Bar. I don't want to see it die. I think this is a great organization. It could be much better. One of the things that also worries me is I look at the membership of the committee. I don't see anybody from Seminole County on it, and most of the attorneys that I see on it are from the 5 or 6 largest counties, population-wise, in Florida. So both of our bar associations have put together written resolutions against reciprocity and non-lawyer ownership of law firms. So I'm going to go ahead and hand them to Mr. Cohen. And thank you everybody for coming here today, especially the people on the committee. Appreciate that.
Thank you, Mr. Vicarious. I've been living through you for years. I couldn't help it. Couldn't help it.
Many people do.
But I will tell you, and I appreciate your relating the story, and I know it had some meaning. But I will share with you that the Florida Bar, at least through the Board of Governors, is alive. It's well. It's a deliberative process, and really, at the very least, what everybody should take away from this is this demonstrates that. So, but I appreciate those comments. Our next speaker is Michael McStratus.
It's time to switch.
All right. Good afternoon, Mr. Cohen. Mr. Vicarious, Atticus Finch is almost dead. The days of Atticus Finch, and everyone loved the story of Atticus Finch. It motivated me to become a lawyer, and I have been a member of the Florida Bar for 45 years. And I can say this, I've been engaged in sole practice. Now I practice for the last year and a half with my daughter. She went to a fourth-tiered law school, okay? She didn't go to one of the fancy law schools, so she really had to study for the bar. And I sat with her, and we went through the bar notes, and it was an interesting study because I learned a lot of law. And the process of being a good lawyer is you got to learn every day. Every day is a new day. And if you're not prepared to do that, then you can't be a good lawyer. But let me say this, okay? I am fearful of the big mega law firms because I do personal injury litigation. I do the slips and falls. I do a lot of cases that a lot of lawyers don't want to have because it's too time consuming or there's questions of liability. But the big firms that owe their allegiance to their stockholders, they have one goal and one goal only, and that is to generate cash flow for their stockholders. Jason Mulholland, my colleague here in the Hillsborough County and the Tampa Bay trial lawyers, hit upon it. He hit upon it very well. They want to delay, they want to obfuscate, they want to prevent the person from getting their day in court. And the longer they can hold out and the longer that they can do it, the more money it is for their clients. There's another concern, and the bar has not touched on this, but you've got mega insurance companies now who have in-house counsel. I ask you, sir, and I ask the Board of Governors, how can a lawyer who works for an insurance company whose profit motive is to return a dividend to their stockholder, how can he go against his employer and say, we need to compensate Mr. Jones. You have exposure on this case. They're going after us on bad faith litigation. That lawyer can't do that because he owes his allegiance. There's conflict all down the line. Let me say this too. As a sole practitioner, now I have my daughter, of course, but I've done this for 45 years. I've had people who've come to me, and quite frankly, they have cases. Classic example is the area of landlord and tenant. And unless I can find a provision in the lease on attorney's fees, I have to tell them, I can't take your case because by the time we go to court, there's no provision in there for you to get compensated and get your attorney's fees paid. And increasingly what I'm seeing today is that clients cannot afford competent legal representation. It's beyond them. Perhaps we ought to look at abolishing the American rule, going to the English rule of winner take all. But that's the situation. Another classic example is, believe it or not, we have debtor prisons in the United States. If you don't believe me, spend some time when the Florida Department of Revenue attempts to collect money from somebody who may be out of a job and they're forced into a criminal contempt citation and they lose their driver's license. They're in prison, debtor's prison in Florida. Thank you.
Thank you, sir. Our next speaker is E.A. Seth Mills from Tampa.
Good afternoon, Mr. Cohen, members of the Bar, Board of Governors, Bill. I know Ray Abedin, and I like Ray Abedin, but this is a crazy thing he's trying to do. I want to tell you a little bit about my story because I think it's relevant and it's a slightly different perspective. I rise in opposition to the proposals from the 2016 Vision Committee. I was a big firm lawyer. I grew up as a big firm lawyer, spending many years in big firms. I then started my own firm, and I've now got a small to medium-sized firm of about 20 lawyers. I've been practicing law in this state for 33 years. I'm a former JAG, and I totally agree with the provisions that others were saying earlier, and exercised a similar one when I was stationed in Colorado, was admitted to their courts while stationed there to do limited things for the government. But having said all of that, I'm here. I also have an office in Atlanta, and I just flew in from that office to come to this meeting. And I took the Georgia bar 25 years after I took and passed the Florida bar. And I want to tell you what people are telling you, have already said about being competent. It's really critical because I've been a board-certified lawyer here for at least 15 to 20, maybe 25 years. I'm not sure. As long as they've had the board certification in my area of practice, I was in the first group that was certified. I can't remember exactly how long ago that was. But the point is, I'm a fairly smart guy, and I tell you, if you're not there every day and you're not practicing there every day, it's difficult to stay up. And I fear, as Justice Lewis was quoted earlier, that this is going to have a significantly detrimental impact on the small litigant. And I don't mean the small firm, but it will there too. I think it will have the effect of nationalizing many of the practice areas that we have. We'll have mega law firms with practice groups that can travel around the country and sell to most of the Fortune 500 companies or others who can afford their services. But that'll eventually be like Walmart crippling what was Main Street, because many of the smaller and medium-sized firms, we have 10 lawyers or less, and 69% of our bar membership are in firms of 10 lawyers or less. Those firms will find it increasingly difficult to survive. Those firms, when they fold, and they will fold mostly, those lawyers will fold mostly into the mega firms because that will be the platform they'll need to compete with. When that happens, the smaller litigants who we have bar members who've stepped up here today have said that they've been representing those folks. They won't have that opportunity anymore. Access to justice will absolutely be affected. I have not come here lightly today because I went around talking to a lot of the younger members of our law firm and around the Hillsborough County Bar. And to the person, I have not yet found one. I heard someone say they've talked to someone that they found two that were in favor of this proposal. I've yet to find one. So in my discussion. So I rise to say I think it's a bad idea, not because it's going to affect me, because it's not. I'm going to be gone before it really grabs its teeth if it were ever passed. But I think it is going to affect the public in a very bad way. And it's going to affect I'm not so much talking about the people in this room. I'm talking about John Q. Public, who needs the people in this room. Thank you.
Thank you. Thank you, Mr. Mills. Our next speaker is Damon Gleason. Apollo Beach.
Damon Gleason.
Gleason.
Over here.
Okay.
I'm Damon Gleason. I'm here both for myself and as chair of the General Practice Solo and Small Firms section. I want to preface my comments and say that I have a lot of trouble restraining my personal opinion on this because I'm passionately against this. And I think it's unfortunate that Section 10A, and this is a mouthful, of the preliminary report of the Multi-Jurisdictional Practice State Focus Committee of the Vision 2016 Bar Admissions Subgroup, a single paragraph is dominating the Vision 2016 discussion. Last Friday, Ray Abedin met with our executive council. And we spent an hour and a half going over this. After Ray left, we took a vote, and we had a plurality to oppose this, but we did not have a majority. But we did pass unanimously a resolution to take a survey and make it very simple. We put in the survey Section 10A, and we did it by email. We gave a link to the Vision 2016 report, preliminary report that's on the bar website, so that people could read it, and we felt that that would be a fair way to do a quick survey. We cut that off yesterday at 5 p.m. We have 1,870 members, and if we put out a email, we just put out an email in the Dade County inviting people to free alcohol, and we got 10 responses. We could put out ice cream or anything, and we'd get 10 or 15 responses. Out of our 1,870 members, we got 150 responses, 112 opposed, 38 supported. And I have a report and a compilation of that. I brought 20 copies of it, and Jay, I'd like to give you a copy. And I want to thank everybody for coming out here and expressing their opinions. Having been in various roles of bar leadership for 20 years, it's really hard to get very busy lawyers out to do anything. And I thought it was remarkable, and our section administrator thought it was remarkable that we got 150 responses in 2 days from our email. So, and I'm very sensitive to everything in Vision 2016. My family was in Hillsborough County 5 generations as cut flower growers. And in a span of 10 years, South American cut flower growers literally ran us out of business. The other issues in Vision 2016 are what we should be discussing, not this Section 10A, one paragraph. We need to get rid of it now so that we can really get to the issues of Vision 2016. Thank you.
Thank you, Damon, and thank you for your hard work on behalf of your section. Our next speaker is Matthew Posgay from Jacksonville.
Thank you so much, Mr. Cohen. I appreciate the time to be here today. I am a trial lawyer in Jacksonville. I've been doing it for over 20 years. It seems like yesterday. And I'm also president of the Jacksonville Justice Association. Personally, and on behalf of our organization, we unanimously oppose any admission by motion and any fee sharing with non-lawyers. Freedom, to me, is not affected when you have minimum legal standards that need to be passed in order to do your job. That's not lack of freedom. That's protecting the citizens of the state. I know I'm kind of preaching to the choir, but when I meet with my clients, and I used to do defense work, I switched to plaintiff's work 7 years ago. I meet with families in their time of need, their time of tragedy. They call clergy members, they call doctors, and yes, they call trial lawyers because they're suffering and they need help. And we as a profession must make sure that they are not subject to undue influence, somebody taking advantage of them, or somebody who isn't giving them sound advice who knows the particular issues in Florida law. Otherwise, they're getting preyed upon and they're getting victimized unnecessarily. A wise attorney told me on a case years ago, if we're going to do our job and get paid for it, we better do our job right. And I think you know who that wise attorney was who told me that on a case where I got beat up on. It wasn't about me, it was about a client I represented. But I've taken that to heart. How can we guarantee the citizens of the state of Florida that the attorney they hire who's going to make money doing work for them is actually doing the job right unless they know the basic issues in Florida law to which they've been hired to represent them for? Professionalism and civility separate us from other professions. That's a badge of honor I wear, and that's something we shouldn't just throw away because we're scared of what might be coming. If passing a test to show you can do your job is too tough, then why does the bar support and promote board certification? Something that I became board certified in civil trial law. Does that mean we throw those tests away and anybody can call themselves an expert? That doesn't make any sense. I'm not here opposing this out of fear. I'm here with other members that I've spoken with out of courage. People brighter than me have said, he is a man of courage who does not run away, but remains at his post and fights against the enemy. Another person brighter than me indicated, there are no easy answers, but there are simple answers. We must have the courage to do what we know is morally right. Yes, a trial lawyer quoting President Ronald Reagan, because it's true. These particular proposals have been shown the light of day, and they've been shown to be far more horrible than what many of us thought. They cannot go forward. We know morally the right thing to do to protect the citizens of the state is to not let these things go forward. Thank you so much for your time today.
Thank you, Matthew, and I'm glad you don't forget those lessons. Our next speaker is Michael Weiner from Tampa.
Thank you very much, Mr. Cohen. I come to you today in my capacity as the current chair of the Workers' Compensation section of the Florida Bar. We are comprised of nearly slightly over 900 members. And in preparation for this meeting today, we actually held a duly noticed, according to our bylaws, meeting so that we could, as a board, take a vote on this measure of reciprocity. I also come to you today in my capacity as the outgoing president of Florida Workers Advocates. That is an organization of approximately 300 lawyers throughout the state who are dedicated towards the practice of representing injured workers. Both of our organizations have gathered, and we strongly oppose this measure of reciprocity. In fact, when the Workers' Comp section convened this morning, it was by a near unanimous vote of 28-2 against the measure of reciprocity. We come into this not from the angle of wanting to protect our own interests and our own well-being as lawyers, but more so from the interest of protecting the public as a whole. We understand that the goal of the bar is not to protect lawyers, but protect the public. And reciprocity does not breed competence to help achieve that objective. What reciprocity does is allow lawyers from other states who are not specialists to come in and begin to invade our practice, such that what we have now are people who are jacks of all trades and masters of none coming into our state and working on cases. The practice of law is not a fungible service. When an orthopedic surgeon does a knee scope, the knee scope that he does in Florida is the same as the knee scope that he's going to do in another state. But a personal injury trial, as an example, in Florida is not the same as a personal injury trial in New York. It's not the same as a personal injury trial in Georgia. And so there are fundamental differences when it comes to the practice of law that I think strongly dictate voting down this measure. So again, we thank you for your time today on behalf of our two organizations. We again want you to know that we strongly oppose this measure.
Thank you very much, Michael. Our next speaker is Gabrielle Munoz Caleri? Okay. Thank you. From Newport Richey.
Good afternoon, everybody. Thank you for this opportunity to speak. So, bottom line up front, I'm in favor of motion by reciprocity, probably along the lines of Mr. Tiffany. I like your style, sir. However, I do tend to think that if the views expressed today are representative of the bar and of the Florida public, then I would not support it. I think that should probably be the result. However, I did want to take this moment to share my reasons why I do support it. I'm a new lawyer, first year solo practice. And to me, it comes down to vision. That's a Vision 2016 vision. In jurisprudence, there's often the discussion of the distinction of the law that is from the law that ought to be. And I think today we're facing a question of the distinction between the lawyer that is and the lawyer that ought to be. I don't think reciprocity will on itself or by itself, solve this. But I do think the vision that I see, and it's a very American vision, is that eventually the answer is every person, every citizen should be able to navigate a legal system and its obstacles and be able to resolve disputes with courtesy. And if the problem is that Florida statutes are so complicated, and that's what we're talking about, that's a much larger problem, and hopefully the other aspects of Vision 2016 will be addressing this complexity. In The American Scholar, Ralph Waldo Emerson warns against hyper-specialization and complexity when he is talking about the ideal American man. And he says that if our society becomes too specialized, then the attorney is nothing more than a statute book. And frankly, with technology, Google would probably be a better statute book than most of us here today. So what it comes down to is, what is a lawyer? An attorney and counselor at law is a trusted advisor. And that's what I strive to be in my first year of practice. And as a trusted advisor, it seems like there may be other things besides just the Florida bar, which test whether or not someone is capable to render legal counsel. And I think that the report I read did mention that this 5-year experience kind of evidence is, a way trying to get at whether or not the person is competent to render, good advice. In conclusion, thank you for this opportunity to speak today. This is my first year, so if future bar meetings and the activities of the bar stay like this, I'll be very pleased. But even if reciprocity is stopped, I do think that all of us have to discuss that changes are coming to the profession of law. So, we better be prepared. But thank you.
Thank you. Thank you very much. Our next speaker is John Cardillo from Naples.
Hello, Jay. I'll be brief, but I've never seen a mic I didn't like. I came here to talk about 2 points. Actually, I came in to talk about bundling, but let me just address the issue that everybody is listening to. I have been involved in the bar for 43 years here, in every capacity. President of local bar, Board of Governors for 10 years, Judicial Qualifications Commission, Florida Bar Foundation. As you go around the state, you develop a sense of pride in being a Florida lawyer. I have learned how good the Florida bar is. And you can compare it to every other state. Florida bar has done more initiatives to improve the practice of law. Why dilute it? That's the first thing. The second thing is, and the main thing I want to address, is bundling. I think when you talk about the independence of the judiciary and the independence of the lawyer, how does bundling enhance independence? Think about, now I don't think any Accenture or insurance company is going to want to buy my firm, which is a 4-person firm in Naples. But when you think about people who are more involved in transactional things and other types of practice, and they get bought out by Accenture, which is mainly not just consulting, but a lot of CPAs and things like that. And there's an argument between the new lawyer who was brought in and purchased by Accenture and a discussion over a client's transaction with the CPA or whomever that has been with Accenture. Who wins? Who pays that lawyer's salary? Accenture pays that lawyer's salary. How is he going to fight when he decides that the other fellow who is more entrenched wins? And then when Accenture decides to sell out, and they sell to a Saudi prince, which you may never know about, how does that enhance the independence of the bar, and how does that enhance the independence of the lawyer? Thank you.
Thank you, John. Thank you, John. I'm familiar with you and your practice. I'm just curious, what are you asking? I'm familiar with you and your practice. What are you asking to sell? How much?
Well, you know, a Dunkin' Donuts and a McDonald's just opened up
sold
next door.
Our next speaker and lady. Oh, I have another one. Okay, I was going to say this will be our last, unless someone has not signed up to speak. But our next to last speaker is Steve Barnes from Tampa.
Governor, thank you for your time. I'm in my 22nd year of practice, and I've always been in a small law firm. I want to first thank the Board of Governors for their efforts. I've got friends on the board. I've got friends that are officers. I know their families. I know their practices. I know how busy they are, and I don't know how they do it. So I want to recognize that and thank you guys. It is true dedication. As I followed this over the summer, you know, it sets up as an us versus them. I don't look at it that way. You guys are our leaders. I want to, as this gentleman over here did, recognize you for forward thinking. But with leadership comes a responsibility sometimes of recognizing an error in judgment. And that can be hard. But I think it's important because whether we're learning this in the home, or we're learning it in the business world, or we're learning it in the practice of law, effective and strong leadership is recognizing an error and learning from it. And I don't want to be preachy. I just want to encourage our leaders to reflect and maybe see if there's been an error in judgment and how we can learn as an organization from that so that we can prepare for the future. I don't want to reiterate everything that's been said. I just want you guys to really come together over these coming months and reflect on what's happened and what's been said in these meetings and effectively lead us into the future. Thanks.
Thank you, Steve. Steve, I appreciate that, and I appreciate those comments. And I will tell you, I adhere to that. I learn something every single day in my trial practice and in my life. And I will tell you that we as a collective group, a very deliberative body that I promise you cares on what we do and how we do things. We've learned a lot, too, from this process. And it's a learning process that we will take forward with every issue that we face in the future concerning the Florida Bar and your Board of Governors. And your Board of Governors cares. They care deeply. The next speaker is, and our last speaker, unless anybody has a card and wishes to speak, is Cole Jeffries from Tampa.
Good afternoon, everyone. I've been licensed to practice as an attorney since 1973. 20 of those years I spent as a Navy JAG, serving in all types of litigation, all types of lobbying effort in Washington, D.C. And then I was fortunate enough to be transferred to Florida as part of the Rapid Deployment Joint Task Force that became CENTCOM. I got involved in the Florida Bar through the Military Aid to Servicemen Committee before I ever considered taking the bar. I took the bar because of some influence I had from young lawyers that I met at a social function at a Florida Bar annual meeting. I never thought twice about taking the bar. I was on active duty. I was spending half my time in Washington, D.C., but I found time to take the Bar-B course, to study, and pass the Florida Bar. And it wasn't that big a deal, in spite of the other duties I had. I agree with, and I oppose admission on motion. I've taken 2 bar exams in my life, and if necessary, I'd do another one. I agree with the other comments that have been made about the potential impact on solo practitioners, small firm practitioners, and a host of other reasons, as well as I agree that we should oppose non-lawyers having any type of possibility of controlling interest of any organization that practices law. However, out of all the comments this afternoon, I turned my card in late because it seems like there's one area that we've missed considering. And I heard it Tuesday night at a town hall meeting. We have gone through the process through the Florida Supreme Court and our Board of Bar Examiners to certify that a large number of young lawyers that are graduates of law schools here or someplace else are competent to practice in Florida. That same group has a huge majority that are either struggling to find a job or struggling to support themselves in solo practice, or they can't find a job at all. Some of them go back to law school for another year because it's easier to live off the loans and get an LLM in tax or something else with the hope that the job market will be better. Some that are very, very bright first and second year law students that I've talked to, they drop out because the market here in Florida has gotten so terrible and they want to stay in Florida and contribute. Each of us in this room that's become an attorney licensed to practice in the state of Florida also has another obligation that has been mentioned this afternoon. We have an obligation to mentor these young people. We have an obligation to each and every one of them. We also have an obligation, I think, to try and create a market for these people. And right now, we're not doing our job. There are just a huge number of them. We have a surplus of lawyers in the state. And I think it's time that perhaps this whole concept of admission on motion is way too premature. It's putting the cart before the horse. We need to concentrate on the improvement, perpetuation of professionalism and competence and a good market for the lawyers that we have already said are competent to practice before we open the gates to admission on motion and we don't know what the quality of their education is, what their knowledge of Florida law is. And as many people have said, we have a lot of idiosyncrasies here. So that's my comment. I don't think that either one of those are good ideas, and I think we need to concentrate. Let's put our money back into the young lawyers and helping them.
Thank you very much, sir. Unless there's anyone else who has anything to add or would like to be heard, and before I call this forum and this meeting over, I want to first of all, and most importantly, thank each and every one of my fellow Florida Bar members who took the time today to come here and to share with us your opinions, to share with us your comments, your thoughts, your voices on this important issue which has candidly galvanized the Florida Bar. I want to thank, again, my fellow Board of Governor members who have been sitting through this entire presentation and who will be prepared to evaluate it on their own, who will be prepared to talk with the fellow Board of Governor members as we do at each and every meeting, as we deliberate these very critical and important issues. I want to thank President-elect Bill Schifino for being here. I want to thank Jack Harkness, our incredible, gifted executive director who has sat through this entire meeting and who continues to provide valuable insight to us as a Board of Governors. So believe me, your input is critical, it's important, it's heard, it's taped, and we will be considering this at our October 16th and 17th Board of Governors meeting. Thank you.